None of which is.
All right, ladies and gentlemen, we're going to go ahead and start our next panel.
Yeah.
To kick things off, let me introduce you to the chair of the panel, Steve Petrus. Steve Petrus is the new director of the Cox International Law Center, and he's doing a terrific job here. Christian Venevasser's plane is a little bit delayed, so he's going to just show up and join the panel in progress. We're also going to carve out 15 minutes right before lunch for him to speak, so you will get to see Christian. But in the meantime, we found another ambassador, Ambassador Todd Buchwald, who was for a long time, the assistant legal advisor for United Nations Affairs, who is very well versed in these issues as well. Steve.
All right. Thank you, Michael, and welcome everyone. After World War II, the world was in shock to learn the extent of atrocities that had been committed by the Nazi regime and wondered how things could have gotten that far. The United States and many of its allies wanted to create a system where nations could act in concert to stop conflicts from ever getting that far out of control. These nations realized that the efforts along these lines after World War I just didn't work. Consequently, the idea of keeping peace, even with force, found its way into the creation of the United Nations. The UN would be a place where debate and dialogue would get in front of and prevent combat. To do this, the UN needed the ability to act, even perhaps intervene in dangerous conflicts that could spin out of control. A long time was spent in negotiations in San Francisco and around the world to come up with a process addressing conflicts and considering sending a military force to quell a conflict. Determining when this could legitimately be done was not easy. Many points of view were presented during the debate, and one of the main issues addressed was who should decide. Should it be the General Assembly? Could it even be accepted that each country's vote would be equal? How could a small island nation vote be of equal weight to that of the USSR, China, or the USA? For many reasons, the big players decided they needed to be in control. Arguably, they had the most at stake and would expect to play the biggest roles. So they were given a superposition within the governance of the UN, that of being permanent members of the Security Council. The UN Charter provided that the Security Council would have 5 permanent members. Initially, it was decided that there would be 6 other rotating members on the Security Council, and later that number of rotating members increased to 10. 5 permanent members were provided a veto, in that decisions of all substantive matters, as the Charter now reads, shall be made by an affirmative vote of 9 members, including the concurring vote of the permanent members. Certainly, sending a peacekeeping force is a substantive matter. So to do so, the Security Council needs 9 or more of its 15 members to vote in favor of such intervention, which with each permanent member either being in agreement or abstaining. This is not only required for using peacekeepers in conflicts between nations, but also where resolutions propose using peacekeepers within a country having significant internal conflicts. If atrocities occur and there are not 9 members of the Security Council who want to intervene, then there is no intervention. If 9 do want to intervene, and any one of the 5 permanent members votes against the resolution, then there is no intervention. In that case, the UN would not stop the atrocity by sending in the peacekeeping troops. Let's presume that there's a conflict within the borders of a sovereign nation and that one ethnic group there seeks to kill all the members of another ethnic group. Let's further assume that 9 members of the Security Council approve that a UN peacekeeping force needs to intervene so as to stop the conflict and let cooler heads prevail. How do we feel about one of the UK, France, China, Russia, or the USA voting against such action and thereby preventing the UN troops from physically trying to stop the genocide. Our panel today is going to deeply analyze this issue, and we are fortunate to have with us a set of true experts who have thought long and hard about this dilemma. And let me introduce them to you. First, Jennifer Trahan is clinical professor at NYU Center for Global Affairs. She has served as counsel and of counsel to the International Justice Program of Human Rights Watch, the Iraq prosecution consultant to the International Center for Transitional Justice, and worked on cases before the Special Court for Sierra Leone and the International Criminal Tribunal for Rwanda. She has published 2 digests on the case law of the ad hoc tribunals, as well as scores of law review articles and book chapters, and she is currently writing a book titled Legal Limits to the Veto in the Face of Atrocity Crimes. She holds her bachelor's from Amherst College, her JD from NYU, and an LLM from Columbia. Next, we have Todd Buchwald. Ambassador Buchwald is a fellow at the Woodrow Wilson Center for Scholars. He was formerly special coordinator for the United States Department of State Office of Global Criminal Justice. He served in the U.S. State Department's Office of the Legal Advisor as Assistant Legal Advisor for Political and Military Affairs and as Assistant Legal Advisor for UN Affairs. He teaches at George Washington University School of Law and presently teaches international law at the University of Oklahoma. His undergraduate degree is from Cornell and his law degree is from Yale. Michael Kelly is a professor at he is the Alan A. Sept Endowed Chair at Creighton University School of Law in Omaha, Nebraska. He focuses his award-winning scholarship on public international law, and he is among the top 3 downloaded nationally and internationally on Social Science Research Network. He is the author of over 40 articles and 7 books, the most recent of which is The Cuba-U.S. Bilateral Relationship, New Pathways and Policy Choices. Professor Kelly serves as the co-chair of the American Bar Association's Task Force on Internet Governance, as well as on the board of directors of the Paris-based International Association of Penal Law. He is developing a matrix on internet human rights that maps the migration of each of the recognized international human rights from our kinetic world to the digital world. He holds his JD from Indiana University and his LLM from Georgetown. Next is Ved Nanda. He is a distinguished university professor and Thompson G. Marsh Professor of Law at the University of Denver, where he founded the International Law Studies Program in 1972, and he directs the Ved Nanda Center for International and Comparative Law. He has received numerous national and international awards, has authored over 24 books and over 225 chapters of law and law review articles. And he has received many distinguished awards, including the highest civilian award given by the government of India. Professor Nanda has been significantly involved in global international law throughout his career, holding numerous positions, including president of the World Jurist Association and the United States delegate and vice chair of the Executive Council of the World Federation of the United Nations Association in Geneva. Professor Nanda earned his BA and MA in Punjab University in India and earned his bachelor's and master's of law from Delhi University in India. He went on to earn an LLM from Northwestern and was a graduate fellow at Yale Law School. So we're going to start our panel discussion now with this distinguished group. And first, we're going to take a look at the historical use of the veto and frame the problem. Jennifer.
Thank you. Thanks, Steve, for that introduction. It's my pleasure to be here, and thanks to Michael, though I don't see him right now, but thank you, Michael, wherever you are, for making this panel one of this terrific conference. So Steve framed the issue, let's assume the Security Council is looking at sending in peacekeepers. But I want to expand it a little bit more, because the question whether to use some form of military force or peacekeeping is kind of your last step. So there are many things that the Security Council can do to condemn crimes when atrocities are starting. And the problem we're dealing with is when the Security Council is prevented from doing these by the veto power. So usually what you would see is kind of a ratcheting up of means, with the Council first perhaps condemning crimes. Maybe it would authorize some kind of investigation. And then it could think of measures such as travel ban on select individuals, or an asset freeze. You could have sanctions. These could be arms, oil, etc. on the country. So there are a variety of these measures. And then even when you get to the issues of use of force, there are always kind of more minimal use of force approaches, such as protecting civilians in IDP camps, authorizing a no-fly zone in the face of aerial bombardment, or humanitarian assistance. I mean, even these are technically use of force if you don't have authorization from the host country, the country where this is happening. So it's a huge variety of measures, and I will be talking about use of the veto, but just to frame it, it's also the threat of the veto. Because when a permanent member says words to effect, we have trouble with that approach, we have objections to that language, etc., that's effectively, if you don't do something about it, we could invoke our veto power, and the other members are kind of left guessing. Does it mean they are going to invoke the veto power or not? And there is also a related problem, and it's really effectively self-censorship of other members on the Council. When, due to a country's political alignment, they know that there are just limitations on the possible. I'll just give you an example. Why don't they table a resolution, let's refer the situation in Myanmar to the ICC? Well, they know 100% that will face veto, may face multiple vetoes. So countries are like, why would we draft this? Why would we go? I actually wish they would, because then the outside world knows what's going on. But they don't often. So we don't see the effect of the veto power. Just historically, to frame it, if you go back to the apartheid era, we have French, US, and UK vetoes. They don't cause complete Security Council paralysis, but they do, to some extent, protect the apartheid regime. It eventually results in mandatory sanctions. In 1994, in the face of the Rwanda genocide, we have a slightly different issue. We do have, I think, what we'd call implicit veto threats by the US and France. Some accounts say by the UK as well. Don't use the word genocide. Whatever you do, don't call the Rwanda genocide a genocide, because it'll look like we have to do something. And there's also, they don't want to authorize troop deployment. So we do have, UNAMIR is stuck in the middle of the genocide with a very minimal troop presence. Eventually UNAMIR 2 gets deployed, but the genocide is largely over at that time. Here, the veto threat is being used. It's actually, at heart, is no country had a plan. No country had the will. They didn't have. So the veto threat isn't what's blocking. I don't think there was an underlying plan. I don't think there was an underlying will that we're going into Rwanda. So it's a slightly different. We know the US uses the veto anytime Israel comes up. Sometimes these would be in the face of atrocity crimes, which I use that phrase, I mean genocide, war crimes, crimes against humanity. Not all such vetoes. It's kind of a complicated picture. China is one of the countries that prefers not to have to expressly veto. An exception would be if Taiwan's at issue, they would invoke an express veto. But China prefers to use veto threats. So we see during the Darfur, the crimes, which I think very clearly amount to genocide, have been charged as genocide. But even if one considers them crimes against humanity and war crimes, my remarks would apply equally to those crimes. China waters down sanctions. It ensures there will be no oil embargo. It limits the arms embargo. Every step of the way, it limits and delays peacekeeping. And in the meanwhile, the height of the killing is all accomplished. And it's not happenstance that China makes sure there's no oil embargo, because Sudan and China obtains oil from Sudan, and China sells arms to Sudan. So when it limited the arms embargo, there was also a rationale, an economic reason for this. Sri Lanka, Myanmar, we again see very little out of the Council. We don't have express vetoes. We have one related to Myanmar, 2007. They would have already condemned the crimes, but no, China doesn't permit this. And of course, what's the problem? That not only don't these measures get passed, but I think it potentially sends a subliminal green light to perpetrators on the ground. You have a protector on the Council. Perhaps our most dispiriting set of vetoes relates to Syria. We have a series of 12 vetoes, and Ambassador Venevezer is now going to join our panel in perfect time. We have a series of 12 vetoes, and I won't run through them all. They're very dispiriting. But first, we can't have condemnation of crimes in Syria. The only condemnation that passes is when there's kind of a moral equivalency between all people committing crimes. If it's at all targeted towards the Assad regime, that gets vetoed. Then we can't have condemnation of indiscriminate aerial bombardment in Aleppo, and we can't have humanitarian assistance in Aleppo. And of course, Russia is militarily involved in this. We can't have referral of the situation to the International Criminal Court. And again, what does this convey to perpetrators on the ground? Oh, the court has no jurisdiction. That's really not the message you want to be sending. And then we have a very dispiriting set of 6 vetoes related to chemical weapons use. And some of these vetoes, 6 of the 12 vetoes in total, are joined by China. And one of the measures that's vetoed on 3 occasions would have renewed the mandate of a joint investigative mechanism that was not only looking at chemical weapons use on the ground, but who was using the chemical weapons. And when this is initially created and the fact-finding mission of the OPCW are deployed to the ground, we actually see a drop in chemical weapons use. And then later, when these get vetoed and we don't have this mechanism in place, we have increased chemical weapons use. So we actually see that the veto is costing lives on the ground. We may not know exactly which ones, but there is a correlation. So I'm going to stop here because that's just framing kind of the problem. Yeah, I'll stop here.
Okay, thank you very much, Jennifer. Next, we're going to go to Professor Kelly, who's going to talk to us about the structure of the Security Council and initiatives to change or reform its operations. Michael.
Thank you, Steve. And thank you for putting together this panel of leading lights in this area. And I just have to, start with recognizing my friend Ved Nanda. Ved is from that generation of international law scholars that included people like Tom Frank and Barry Carter and Sharif Bassiouni that in the 70s and 80s really made international law tangible and workable and gave us something to work with in our generation. So thank you, Ved, for all your work on that. So, of course, any discussion of Security Council reform immediately runs into 2 rather vexing issues. First is the problem of politics. The P5 will act like ostriches and put their heads in the sand because they don't really want to talk about reform of the Security Council in general or reform of permanent membership in particular or the veto generally. Second is the problem of amendment. No structural reform or little structural reform can be implemented without opening the charter to amendment unless you do it through some procedural path. And when you open the charter for amendment, you're going to have to take those amendments to the national legislatures. Now, when this hits Congress, I'll just stop right there. You can imagine what that's going to look like. A 2014 report from the Council on Foreign Relations said that at present, support in Congress for amending the UN Charter is irresolute. So that's sort of the understatement of the day. What I'm going to talk about is a trio of structural reforms that I first talked about 20 years ago in New York at the United Nations. One is reconfiguration of permanent membership to include regional seats. Second is rethinking the veto power and reframing it. And third is increased transparency. So with respect to permanent membership, I mean, we start with the proposition that everybody knows this is self-dealing, right? 1945, 46, the victorious allies from World War II said, all right, let's set up a collective security arrangement so we don't do this again. And let's put ourselves in charge of that. And let's make ourselves unquestionable. And that's what we have. We have the United States, Britain, France, China, and Russia sitting in the seats as the P5 with the veto power, calling most of the shots. But a lot has changed in the 73 years since that bargain was struck. Two of the P5 seats of the original members are now filled by successor states, the Soviet Union's seat to Russia and the Republic of China's seat to the People's Republic. In 1946, there were 51 states in the world. Today, there are 194. At that time, France and Britain controlled much of the territory in Africa and Asia via colonial subjugation. During the Cold War, the P5 had a monopoly on nuclear weapons. Today, other states have them, including India, Pakistan, North Korea, and Israel, or had them and gave them up, like South Africa, or are developing them. The P5 also embodied the largest economies of the world. While the United States and China remain the top two, Japan and Germany are next. Japan and Germany, of course, are still referred to as enemy states in the Charter. A fact they don't really appreciate, and would like to change that as well. Germany's followed by Britain. France is no longer in the top 5 in world economies, falling in the 6th spot. Russia isn't even in the top 10, lagging behind India, Italy, Brazil, and Canada. When the Berlin Wall fell in 1989, the 7 largest Western economies, 3 of which have permanent seats on the Council, accounted for 51% of the global economic output. Today, they account for only 30%. So any political, military, or economic rationales of P5 membership that may have made sense in 1946 have all but evaporated. And yet, here we are, sort of frozen in time. Calls for the Security Council's expansion in permanent membership have taken a variety of forms over the years. This really sped up in the 1990s and gained a bit more steam towards the turn of the century, but has quieted down a bit since then. All kinds of formulas have been in play, including expanding the council, to up to 30 members, some with vetoes, some without, eliminating the veto altogether, making certain adjustments. I think probably a moderated approach, and this is taking into account and endorsing the rationale that increased representativeness on the council increases its legitimacy. The P5 are not representative from a diversity standpoint in any way, shape, or form, ethnically, religiously, geographically, however you want to slice and dice that. And so increasing that has inherent value. I think the best way to do this without increasing permanent membership to the point that the council becomes unworkable and maintaining the values of efficiency and all that comes with that would be to create and then fill regional seats, one from Latin America, one from Europe, one from Asia, and one from Africa, that permanent members serve for 2 years and then rotate out and then get back in line to serve again. 3 states for each regional rotating seat. But I think the accommodation that needs to be struck is that the U.S., China, and Russia maintain their seats, because that's really non-negotiable. The question of Britain and France is a perpetual question. And when I raised this 20 years ago, the idea of perhaps them sharing a seat with Germany to fill the regional seat for Europe, I was presenting this in New York, and to my left was a fellow from Oxford, and to my right was a woman from the Sorbonne. And as I was stating this, I could literally feel the icy chills going into my ears. But stuff has changed in 20 years. France now is talking about limiting veto use, as you all know, and as we'll hear about today. The Brits, gave up their seat on the International Court of Justice. That was unthinkable 20 years ago, that we wouldn't have every P5 member represented on the ICJ. So, I mean, there's some question as to whether or not there might be movement there. With the other seats, I think we have obvious candidates from each region. With the Asian seat shared among Japan, India, and either Indonesia and Pakistan, this arrangement achieves the goals of getting both Japan and India onto the council, while also providing for periodic Muslim representation. With the Latin American seat, a shared arrangement between Brazil, Mexico, and either Argentina or Chile simultaneously achieves the goal of elevating Brazil, while also ensuring periodic representation from Spanish Latin America. And with the African seat being shared among South Africa and Egypt, and either Kenya or Nigeria, this accommodation places both the leaders of Saharan and Sub-Saharan Africa on the council, while also recognizing the economic importance of regional influencers. In all 4 cases, the geographic rotating permanent seats bring new voices to the table with increased authority, reward the long-standing economic and military contributions these countries regularly make to the UN budget and peacekeeping operations, and recognize the historical leadership each state has undertaken in its respective region, while only increasing permanent membership from 5 to 7. So it's not an explosion of the permanent membership that some people advocate. With respect to the veto problem, very quickly, because I'm running out of time, the current iteration of the veto is substantive in nature, and I'm using that in a constitutional sense. If assent is withheld on any resolution, the matter is over. What I would advocate for the new permanent regional rotating states is a procedural form of veto, where when that veto is cast, the matter isn't killed automatically, and that's why it's procedural in nature. It's instead referred over to a standing committee of the General Assembly for consideration and discussion, without the possibility of amendment, up or down vote, and then it's returned back to the Security Council. This achieves multiple things. It gets the new permanent members onto the council with a veto power, even though it's not the veto power. But it also co-opts the General Assembly into the discussion, which was one of the things we wanted all those years ago when we were talking about uniting for peace, and it increases communication. And then lastly, sorry I didn't get to unpack that very well, but you can read the article. Lastly is increased transparency. In the 1990s, Germany resurrected the old idea of having to explain yourself if you cast a veto. The requirement that if you're going to cast a veto, the cost of doing that is providing the rationale for why it's cast. You don't just throw it on the table and walk away. Now, sometimes explanations are forthcoming, sometimes they're not. Most of the time, we can figure them out. But you have to sort of defend the fact that you did this. I think taken together, reconfiguration of the permanent seats to include expansion and realignment of shared regional seats, implementation of a procedural veto for new members, and an explanatory requirement in each instance of veto use by a council member. This package of structural reforms yields a Security Council with increased legitimacy through greater representativeness, decreased possibility of substantive veto use in any one session, increased interactivity with the General Assembly, and increased transparency with rationales accompanying all veto usages. Returning to the central question posed by the editors of this symposium, one would expect to see, extending from this suite of reforms, a significant diminution in the use of veto power to protect states that commit mass atrocities, increased accountability through increased communication and transparency, and increased representativeness through more regional seats sitting as permanent members, while only marginally increasing the size of the council, is key to this outcome. I would close by saying it's one thing for a permanent member to cast a veto to shield a reprehensible client state without consequence on a council where the members of the club have not changed in 70 years. But it's quite another thing to cast that same veto looking eye to eye with another permanent member from the region where those atrocities are unfolding and having to explain yourself. Thank you, Steve.
Thank you very much. I'm now going to turn the comments over to Ambassador Christian Benavasser, just walked in, so I'm putting you on the spot. But before I do, I would like to introduce him to you. Since 2002, Ambassador Benavasser has been the permanent representative of Liechtenstein to the United Nations. In 2008, Ambassador Benavasser was elected to a 3-year term as the president of the Assembly of States Parties of the International Criminal Court. From 2003 until his election as president, he chaired the Special Working Group on the Crimes of Aggression for the Assembly of State Parties. At the United Nations, Ambassador Benavasser served as chairman of the Third Committee, dealing chiefly with human rights issues during the 57th session of the General Assembly, and as vice chair of the Open-Ended Working Group on Security Council Reform, and as advisor on Security Council Reform during the 59th session. Ambassador Benavasser was educated at the University of Zurich, the Graduate Institute of International and Development Studies in Geneva, and the Bavarian Academy of Sciences and Humanities in Munich, Germany. So, Ambassador Benavasser, the floor is yours.
Thank you so much. Apologies for my delay. It was out of my control, obviously. So it's a real pleasure to be here. Thanks for the invitation, Michael. It's wonderful to be back, and it's great to see so many friends. I'll offer comments on, we're still framing the issue, correct? So I'm going to...
You could talk about your wonderful work on the Code of Conduct, because
Okay.
you're one of the leaders in this field, and I think the audience would love to hear about that, as well as your new initiative.
Good. Okay, so Jennifer has framed the problem, as others have. We're having this conversation the day after the 13th veto was cast in the Security Council on Syria yesterday, that had asked for a ceasefire in Idlib, and this is the easiest way to illustrate the role that the veto is currently playing. And I think it is fair to say that at this point the Security Council is, in fact, not able to carry out its function to maintain peace and security internationally. I think the Security Council is able to do so in a very selective manner, and mainly with respect to some conflicts in Africa. But the divisions among the permanent members are so profound and are so fundamental at this point that the divisions, be it on Syria, be it on Iran, be it on Ukraine, be it on many of the other conflicts, are such that effective council action on these crises is effectively not available. And I think that is the reality today, and the number of the vetoes cast on Syria is simply the most obvious illustration of that. Now, states have long held, in a way, almost ideological views on the veto. The veto was opposed in the discussions in San Francisco. Many states did feel at the time it was not a good idea to allow 5 states to be able to overrule a strong majority in the Security Council. That view did not prevail in San Francisco, but on paper it is still the majority view in the UN membership, and sometimes people forget that. So everybody who is a member of the non-aligned movement has the view that the veto should be abolished, that there should be no veto in the UN Security Council. Now that is a position that is not realistic to implement. We have heard about the prospects of amending the Charter of the United Nations, and that would not be an issue only in the U.S. Congress. The difficulty of amending the Charter of the United Nations is compounded by the fact that all 5 permanent members have to agree to amending the Charter of the United Nations. So the only ones who can take away the veto from the permanent 5 members are the permanent 5 members themselves. So this is obviously a very circular discussion. It is also worth noting that 2 of the P5 have not cast a veto in a very long time. In my view, they have a de facto moratorium on the use of the veto, and that is France and the UK, who have cast their last veto 30 years ago. I think for both countries at this point, it's extremely unlikely that they would resort to using the veto, and I think they would do pretty much everything possible to avoid any scenario in which they would see themselves forced to do so. I do believe it's in a way fair to say that they have a de facto moratorium on the use of the veto, and that is important, and I think that is also an opening for the rest of us. So we are among the states that are very critical, not so much of the veto as such. We accept it as a political reality. We have accepted that when we ratified the Charter of the United Nations. So we do accept that the veto does exist. What we do not accept is the fact in which it is used. And it is, in our view, used very often against the purposes and the principles of the United Nations Charter. And that, in our view, very clearly was not the intention of the drafters of that document. So let me talk briefly about 2 initiatives. One that we have implemented, one we're in the process of proposing. The first is the limitation of the use in situations of atrocity crimes. You have heard about an initiative by France, later joined by Mexico, to have a commitment to not use the veto in situations where the Council deliberates on atrocity crimes. That is something that we have picked up, that we think is in principle a good idea, but it's also something that we believe does not go far enough. We have turned this into a political commitment that is not limited to the permanent members of the Security Council, because we very strongly believe that there should be ownership in the entire membership over issues of mass atrocity crimes. So the Code of Conduct is a political commitment to take positive action to end and prevent atrocity crimes. So this is the first element. So if you subscribe to the Code of Conduct, and the 120 states have done so since a few days ago when Armenia joined, these countries commit themselves that when they serve on the Security Council, they pledge to try to take action to end and prevent atrocity crimes. So that is one part of the commitment. The second part is the commitment to not vote against resolutions that are put forward to that effect. So that is sort of the veto part, but it's not limited to the veto holding powers. It also extends to the elected members that we believe can play an extremely important role, especially when it comes to these situations, because very often, in fact, the proposal is not even put forward because people think it will be vetoed. So to have a positive commitment to say, I will do everything that I can to end and prevent atrocity crimes, is something that fills a very important gap in the policy making in the Council. If you take, for example, the situation in Myanmar, where we all know how atrocious the crimes are that have been committed, the Security Council was never seized with a proposal to deal with that situation. So this is the code of conduct that gives a very important role in addition to the UN system, and in particular and very specifically to the Secretary General of the United Nations, who is asked to put relevant information before the Council. So we are trying to also establish a system, a mechanism under which the UN system sends relevant information to the Council. So the Council is in a way compelled and forced to act. As you know, that has been in the past an issue. For example, with respect to Rwanda, there was a big controversy on whether or not the information available was put before the Council in time, or in fact it is clear that it was not. So we're trying to get the SG, Secretary General of the United Nations, to play a very crucial role with respect to this. Our second initiative, so the Code of Conduct was one that we led as drafters, and as I just said, was joined by 119 other states, including France and the United Kingdom, but not the other 3 permanent members. Our second initiative is being proposed, and we're consulting on it right now. It has to do with what you just heard in a way, namely the role of the General Assembly. What we want to establish is a system under which every time a veto is cast in the Security Council, the General Assembly of the United Nations automatically is seized with the topic that was under discussion in the Council when the proposal was vetoed. Automatically means it happens irrespective of the substance of the proposal, so it's not limited to atrocity crimes. It can be any veto on any issue. It is happening through the convening of the GA by the President of the General Assembly within 2 weeks, so there's a set time frame, and it is open-ended in outcome. That means the General Assembly can take action on a proposal before it, but it does not have to do so. We think that it is important to have that provision because more than anything else, this is an accountability mechanism. We are of the view that the Charter stipulates very clearly that the Council does its work on behalf of the entire membership. The entire membership is represented in the General Assembly. So that discussion should be held in the GA, and we all should be able to express ourselves. Of course, we want to hear from the states that, vetoed why they did that, but usually, in fact, they say so. The Russians did speak yesterday, and they said, why, in their view, the proposal presented by Belgium, Germany, and Kuwait was not a good proposal. But we also want to be able to say what we think and perhaps propose something different, a course of action that the GA can decide on, because we are very strongly of the view that the General Assembly must play a more forceful, a more strong, and a more determined role in a time where the Security Council is so often paralyzed and unable to carry out its functions. Thank you.
Thank you very much. All right, so we've now framed the issue.
You know who you are.
And we've heard about the operations of the Security Council, as well as a proposal on how that should be amended and reformed. We've heard about initiatives about using a code of conduct and requiring that the use of the veto be reviewed or the issue be seized by the General Assembly. We're now going to ask Professor Trahan to discuss a legal analysis of the unrestrained use of the veto and whether or not there are legal theories as to whether that's appropriate. So, Jennifer.
Great, thanks. And, I just want to say that I think work as Ambassador Van Wezer is doing is so very, very important because it galvanizes states at the UN that this is a problem. And he has almost 2/3 of the UN saying this is really a problem how the veto is being used, and we need to commit to positive action. And it's really driving progress at the UN, and even sometimes in an incremental way, but sometimes that's how the UN works. So, we're in a law school, so I will observe very technically that when we talk about a code of conduct, you all know this is a soft law document. And I think our greater problem is we see no interest of 3 of the P5 in joining these kinds of soft law documents. So we do have the French-Mexican Initiative, which is led by France, and the UK is party to the Code of Conduct, as is France. But when we omit 3 of the P5, then we still have these difficulties. So my proposal is to revisit what hard law legal obligations, some of the very obligations that Sean talked about preventing crimes, how that interacts with the veto power. And I am the author of the one-page handout that you may have received when you walked in, which kind of gives a synopsis in very brief form of the 3 main legal arguments. And it does on the back list some of the individuals who are supporting me in this, including my dear friend David Crane, who is here, and I greatly appreciate his support, and various NGOs as well who support this, as well as some of the tribunal prosecutors who acknowledge the problematic use of the veto in the face of atrocity crimes. So I have thought of chiefly 3 legal arguments that could be considered, and I think of them kind of hierarchically. The first is the interaction of the veto power and what we call jus cogens. So we're in law school. Most of you are case students or graduates, so you all know jus cogens are our highest level of international law norms from which no derogations can be permitted. We always say genocide, crimes against humanity, and war crimes are in this basket of jus cogens norms. So we say they're absolutely the highest level of protection. So then we have this veto power, and it sits in Article 27.3 of the UN Charter. 27.3 doesn't use the word veto, but it's read in there because it requires the concurring votes, and it's also read to permit abstention. So I think we have to, one legal argument is how do we say these are the highest level of protections, and is it okay to then have absolutely unrestrained veto use in the face of these crimes? I think one can think of 3 reasons why it should not be. First, it arguably facilitates the crimes. Now, this is my most aggressive formulation, but when you have a joint investigative mechanism that seemed to be deterring chemical weapons use, and then you have that vetoed, and you have more chemical weapons attacks, and there's a direct linkage there. Okay, so this is a very aggressive formulation, but honestly, it is facilitating the crimes. A second, maybe less charged way to put it, we could look at the ILC articles on the responsibility of states. Sean talked about the need for cooperation, and an ILC article on the responsibility of states regarding internationally wrongful acts, Article 41.1, says there is an obligation to cooperate to bring to an end any serious breach of a peremptory norm. Is this what states on the Security Council are doing? Are they cooperating to end these crimes when they use their vetoes? It seems not. And these ILC articles are frequently, they are not necessarily a hard law source of law, but they are frequently cited by the ICJ, and this one in particular has been. A third way we might formulate it is, at minimum, it's inconsistent. We say these are deserving of the highest level of protection, and yet you can freely veto regardless of what atrocities are going on. At minimum, it's inconsistent. And so I would argue for a harmonious interpretation. I'm here borrowing from a doctrine of jurisprudence that is in some of the European courts. They're construing how do we consider European conventional obligations and resolutions under the Charter. They did this in the context of sanctions and detention authority, and they said, well, they should be harmonious. So I borrowed this as well. So I think we have serious, solid legal arguments regarding jus cogens. Maybe the easier argument is the second argument. Gee, the vetoes in the Charter and 24.2 of the Charter says the Security Council has to adhere to the UN's purposes and principles. So when the P5 got this veto power in 1945, it wasn't unlimited. It had certain limits, and this is one. So 1.1 of the Charter talks about principles of justice in international law. 1.3 of the Charter talks about human rights, and Article 2 of the Charter talks about good faith. Are these vetoes? Are these in good faith? Are they serving human rights, international justice, and international law? It looks pretty clearly these vetoes are out of line of the Charter, which means, for instance, looking at the words of the Tadic case, they're ultra virus to the proper exercise of Security Council power. And it's interesting to see states at the UN increasingly make this argument about the importance of the purposes and principles of the Charter. In a debate on May 17 of 2018, there was a debate on the relationship of the Security Council and international law. And numerous states talked about the abuse of the veto power, and it's out of line with international law and international legal obligations, which is really important because it also shows that states are not acquiescing to this practice, but are persistent objectors. My third legal argument is looking at the obligations to prevent these crimes. And we heard about, from Sean in his remarks, Article 1 of the Genocide Convention, the obligation to prevent genocide. We now know it has actually some robust content behind it because the ICJ and the Bosnia-Serbia decision says it is based, as Sean said, on a state's ability to influence. Well, gee, does a P5 have an ability to influence? I just leave you with that. And we also heard it carries an extraterritorial component, so it's not only to prevent genocide in your territory, but vis-a-vis other states. There's a parallel provision in the Geneva Conventions. It's called Common Article 1. It says a state must respect the Geneva Conventions, and that means on its territory. But ensure respect means the extraterritorial aspect, that it must ensure respect for the Geneva Conventions. We have the same parallel common article in Protocols 1 and 3. Is this what the permanent members are doing? This argument is complicated by Article 1 of 3 of the Charter, but I can share my writing on that. So in essence, I think these arguments need to be raised. They could be raised in a variety of contexts. I think they would be particularly helpful for elected members of the Security Council to be able to use these. All states can use these in the General Assembly and other fora. And by the way, these obligations to prevent would also apply to other states. They should be exercising every means of influence to ensure these crimes do not occur. Another means we could envision would be the General Assembly asking the International Court of Justice for an advisory opinion. So the GA can do this. And it would be on a question something like that. If there's ongoing genocide, war crimes, crimes against humanity, is it fully legal for the permanent members of the Security Council to cast their veto? Just a simple question like that. And perhaps another way one could envision this would be states in the General Assembly memorializing some of these hard law obligations in a resolution. So these are kind of the ways this could potentially be operationalized. Thank you.
Thank you. Thank you, Jennifer. Now, I'd like to ask Professor Nanda to address the Uniting for Peace and Responsibility to Protect concepts and present your additional observations and comments on these issues.
Well, thank you very much. First, I want to thank Michael and congratulate him for having this symposium. But you know, this is not the only time. Every time on a cutting-edge issue, he has got people from all over the country and around the world to get together. So congratulations, Mike. And you know, when I talk of Michael, I need to talk about all Michaels. Thank you for your very kind words, Michael. I want to provide a context because the question that Michael raised is challenges, legal challenges. Why do we want to have legal challenges? And the reason simply is that we need to ensure that populations are protected from these atrocity crimes. And then so the context simply is that as the time the Yalta formula came about, the talk was that we must not permit any effort or any action in order to do those kind of crimes. And these 5 veto wielding countries can assure that. You might remember that reportedly it was the United States delegation that asked the Secretary General to put this issue on the agenda. And the reason simply was that on the issue pertaining to Korea, after Korean War had begun, and Soviet Union was using veto, and that is how the Uniting for Peace became a reality. When veto issue came up, you might recall that at that time, in this United Nations framers sitting in San Francisco felt very strongly that there should be these 5 permanent members at that time, 4 major powers, China, Russia, at that time Soviet Union, United States, and Britain. And they felt that veto was essential. That is the context. Reportedly, Senator Connolly, at one of those meetings, took the charter in his hand, tore it. And at that time, he said to all these 45 other countries that, sure, you have seen what has happened. And he said, you can go home and you can say that you fought veto, but at the same time, they are going to say to you, where is the organization? Because there is going to be no United Nations unless there is a veto. In any event, the Uniting for Peace resolution was adopted in November 5 of 1950, almost 7 decades ago. And the resolution simply said, and I want to read part of it, that if the Security Council fails in its primary responsibility for the maintenance of international security, in any case, and then you know those triggers, Article 39, act of aggression, threat of peace, breach of peace. And he said at that time, then the General Assembly can be convoked, and the General Assembly can then provide for collective measures. And collective measures because there is either an act of aggression or breach of the peace. And that's the setting in which the Uniting for Peace happened. Several issues. How can you bring General Assembly together? And the United Nations Charter says there are 2 ways to do that. Either the Security Council can refer the issue to the General Assembly, or General Assembly by majority vote can do that. And what kind of vote from the Security Council? It was not going to be substantive issue that can be vetoed. It would be procedural vote. And that meant that at that time, all these 5 permanent members won't have a veto on that issue. Then the question arose that, all right, this General Assembly is convened. What can it do? It can simply make recommendations, and at the same time, United Nations Charter says that if the Security Council is seized of an issue and it's exercising its functions pertaining to that issue, General Assembly cannot do anything. And then Article 12 does talk about the possibility that perhaps if it's non-coercive measures, the General Assembly can take action. And the United Nations, I think as you look back, International Court of Justice and the International Court of Justice in the Wall case said that even if the Security Council is seized of an issue, General Assembly also can work on it. That is how the United Nations Charter has evolved. Then the question comes up in the, what do you do when action is required? And action is required only by the Security Council. And the answer was given again by the International Court of Justice, and it said that now we have evolved to a point where General Assembly and Security Council both on the same issue can simultaneously work. So the main issue comes up that non-coercive measures are okay, but what about the use of force? And on the use of force, Article 2.4, that has become kind of jus cogens, how do you fight that? How do you permit the General Assembly to take action that is coercive measures? There are two possibilities. One was that it's only an organization that can use force, not the member states, because Article 2.4 talks about member states, not the organization. And if the Security Council can do that, General Assembly can also do that. The flaw with that argument is that that gives a license to every international organization and regional organization to be able to do that. So the second possibility that has been explored at the present time is that 2.4 is there, but 2.4 does not talk about the possibility of having, for example, self-defense or Chapter 7. So they have kind of evolved outside Article 2.4. Similarly, General Assembly's action, use of force can be used in that way. And as you think about the responsibility to protect, the idea was a simple one. After Rwanda happened, before that, killing fields of Cambodia, after that, Srebrenica, and Central Europe was burning. And the point simply is that on Kofi Annan's watch, those things had happened. So Kofi Annan simply said, let's find a way out of it. You don't like humanitarian intervention? That's all right. And that's how the responsibility to protect was agreed after many think tanks, governments had talked about it. And so the thought simply was that every country, every government has the responsibility to protect its own citizens. And under circumstances when manifestly it's failing to do that, at that time, collectively, through Security Council, action can be taken, and that action can be the use of force. So that is the setting in which the responsibility to protect happened. Libya, it was used. Later on, it had not been used because Russia and China, among others, had felt that in Libya it was misused. It was not simply to protect civilian population. It was there to change the regime, and regime change is not permitted. In any event, the point simply is that challenges, legal challenges to veto have a goal, and that goal is to protect the populations. For that protection, there are all kinds of means being thought about in all this journey of 70 years from the Uniting for Peace, and now we find what responsibility to protect, and that is really the effort that has been made so far.
Thank you. Thank you very much. So now, Ambassador Buchwald, you among us are a person who actually served in the State Department addressing UN affairs. You did that for a country that is one of the permanent members, has a veto power, and has exercised that power. What is your assessment or review of these efforts and issues concerning the use of the veto?
Thank you, Steve. So I'll be very brief because I don't want to get one of those signs. This morning, Professor Murphy spoke about laws and means for channeling power, and I think legal proposals are a means for channeling power too. I don't think that the idea of actually reframing the legal structure is going to work. The support in this country, for sure, will never rise above the level of irresolute, which way overstates the level of support. It's just not going to happen. I think Professor Tran's idea is to sort of, in a way, sort of recognizes that and to sort of come up with a legal interpretation that doesn't require action by states to affect the legal change in a way. And I honestly don't think that's going to work either. The question isn't whether, in some abstract way, it is considered that the Security Council passed a resolution that the Russians vetoed or that we, the United States, vetoed. The question is whether people are going to act on it. Right? The question is when the UN, when the Security Council has a resolution saying that saying that the force can be used in Syria, and the Russians veto it and the Chinese veto it. Whether states like us and the British and the French will be willing to say, we don't think the veto was lawful and we'll do it anyway. And it's not just that question, it's the question whether that is the most likely way to get to the answer where people will use force over a veto, if that's a better way to get to it than other ways. And what you see, I think, is legal proposals as a means for channeling power. What you see is all these other ways that the international system comes up to try to sort of get around this problem of there's no Security Council, and it's maddening and it's not particularly effective. But I'm not sure that there's anything sort of better than it. I think what you see over time is a shift of power and action to the General Assembly. I think that's inevitable. You have the Syrian mechanism, the Burma mechanism, the Myanmar mechanism. You have Uniting for Peace itself as an example of, if the Security Council is not going to do it, we're going to try to sort of find another way, and including other ways to put pressure on security members to sort of shame them into not irresponsibly using the veto. I think it is very hard to come up with a neutral way to express what is the test for irresponsibly using the veto. You and I, for sure, would not agree with it, but if you ask the Russians whether they're being responsible, they would say, no, we're not being irresponsible. We think it will make things worse rather than better. That's what they think. And it may be that you know that it's wrong in your heart, but it will be hard to come up with an international mechanism, a neutral international mechanism that rules that that's wrong. So I think what we'll have over time is more like Ambassador Van der Weester's idea of throwing more. In a way, what you do is you not only give a forum for expressing opposition, but it's a way to shame the Security Council members. The underlying problem is the Security Council members are feeling less and less shame over time. And it's, when I was there, it was like the Russian Chinese. There was a concerted effort to sort of have Security Council resolutions continue to come forward, knowing they were going to be vetoed, as a way to sort of shame the vetoers into not vetoing and putting political costs to it. And the problem is it's not working. But I do think what's working is you'll have more pressure to do sort of Kosovos, more pressure to embrace humanitarian intervention. And ultimately, the problem is not the lack of a theory of humanitarian intervention, not a lack of a theory that states can act as a lawful matter in the absence of a normal Security Council resolution. The underlying problem is that states aren't willing to do it. States aren't, there's not a signal from policymakers to their lawyers to say, look, we want to intervene in Syria. Tell us how we can do it. Tell us the legal theory that'll make it happen. If lawyers were getting that signal, there would be a lot more sort of action, a lot more making that happen. But in fact, the world is moving in an unfortunately opposite direction. So I don't think it's the question of the veto as such. That's a huge problem, but I think there's a more structural problem underneath it.
Okay, thank you. I think we have time for some questions. And before we do that, I promised, Jennifer, you have 1 minute.
So in 1 minute, I think Todd is misframing it because I very carefully said I'm not talking about use of force, but even little baby steps can't get out of the Security Council. At the end of the day, it could be a force issue, but even condemnation of the crimes, you got to start there. And weapons inspections regimes, these were working. Russia thinks they're exercising it in good faith. In the siege of Aleppo, let's be real, they wanted to take Aleppo. They didn't want the humanitarian assistance. They didn't want condemnation of aerial bombardment. They wanted to seize it militarily. So I reject that they could even articulate a good faith rationale for some of these. And finally, my initiative is another way to put pressure on the P5. So I'm trying to move in the very same direction as Ambassador Van der Weeser and saying these legal arguments exist. And it is another way to say we really could push this legally if you don't behave. So it's trying to ultimately increase the shame factor and put more leverage and getting individuals to join on and NGOs to join on in supporting this. So,
all right, thank you. Now, Michael, first question.
Thank you. Use the prerogative of the shorter My question is for Christian. One of the things that hasn't been mentioned is the amazing role that you played in the creation of the General Assembly's Triple IM, the investigative mechanism for Syria. And in a new book that Melina Stereo and Paul Williams and I have just sent to Cambridge for publication, we describe that as the largest power shift away from the Security Council and to the General Assembly since the 1950 Uniting for Peace resolution. My question for you is, if that power shift has begun, where do you see that going?
Well, thanks, Michael. It's very nice to hear that, of course, but we really did look at it that way as well. I mean, the genesis of that, of our decision to put something before the GA on accountability in Syria was the veto of the ICC referral. So we think the ICC is the natural place to have jurisdiction over these crimes. That's what we have the ICC for. Now that was vetoed, and there was no prospect of having it resubmitted and not vetoed again. So there's two things we can do, and one is nothing, which unfortunately many of my colleagues prefer doing, or you can think of an alternative, and the alternative was just to say, well, we create something new, and we do it in the GA, and the GA, is so important because it reflects the collective political will of the membership. And, we had 15 states that voted against that proposal, 15 out of 193. That doesn't mean all the others voted in favor, but if we had 105 in favor, and then we had the abstentions. And that shows, where the numbers are. And I think, and that's also what I said in my presentation here, the dynamic in the Security Council is not going to change. So things between the US and China are far more difficult now than they were 5 years ago. Things between the US and Russia are not easier than they were 5 years ago. And there are so many conflicts where the Security Council will simply not do anything of any consequence. That's just a reality. So again, for the rest of us, we can say, well, the UN is nice for climate change and is nice for sustainable development, but it's not an organization for international peace and security anymore. But that's the purpose of the UN. I mean, that's not the only purpose, but that's why people got together in San Francisco. And the risk of armed conflict today is not smaller than it was 15 years ago. It is bigger. So I think it really is our responsibility as members to say, look, we delegated this authority to you, but unfortunately, you're not doing your job. And we're not just going to sit here and, and lament that. We will do something ourselves and take things in our hands. And of course, Uniting for Peace is the reflection of that philosophy. That is a very old resolution. So we have all the tools. And, we need more political will, and we cannot leave it to those in the Security Council to do it. I think it's important to, we are sort of realists in a way. Say, look, the veto exists. We're not going to get rid of it. And let's face it, somebody said it, without the veto, you wouldn't have the US in the UN or China at this point, or probably Russia. So that's just where we are. But the question is, does this mean that we have to accept it all the time under all circumstances? I think the answer to that is clearly no. I think it is very clear that the majority of states feel very differently about that. And I think it's important to ask the question that Jennifer asks in a way, is it legally always, compatible with, in fact, with the Charter of the United Nations? I think it's a very important question, because if you talk to the Russians, they say, look, here's Article 27.3. It says if we vote against a proposal, it's not adopted, and that's it, and we all go home. For us, that's not where the conversation ends, and it shouldn't.
Other questions? Yes.
Thank you so much. The panel was really rich, and I really appreciated the discussion. In my sort of thinking about where international law is right now, it's sort of we're in the era of the workaround, because we have a really creaky system that's strained to the breaking point in a lot of ways, as Ambassador Venevaser said, is dysfunctional. And so there are lots of different ways. If you're in a constitutional crisis, right, which the international system is in, you can either adjust by reinterpretation. You can sort of use the constitutional moment theory kind of Bruce Ackerman. Or you can try to amend it, which is Michael sort of going right at the problem, which is we're going to fix it structurally. And so I think what I'm hearing from the panel is that most people think we have to do workarounds because we can't actually go at these structural problems. But the danger, of course, is when you work around and work around and work around is eventually you end up with a collapse of the system. So I would just love, as you're finishing your remarks, sort of what's going to work right now, or is it going to take some huge crisis to get us to Michael Kelly's argument that we actually need structural reform, or can we keep doing the workarounds through Jennifer's proposal, through the Code of Conduct, through the United for Peace resolution? So that's sort of, I'd love your thoughts about that.
Well, one of the points that was brought out, I think, by a few of us was the distinction between actual use of the veto and the threat of the veto. And the threat of the veto happens way more often than the use of the veto, and it kills things before they even see the light of day. I would maybe amend this fantastic concept note that Jennifer put together, which really makes the case legally that when a veto is cast, when it's a situation dealing with atrocity crimes, that runs against the object and purpose of the charter. And I would, the charter is a multilateral treaty. So I would pull out what you look at when you interpret a multilateral treaty, the Vienna Convention on the Law of Treaties, and go to Article 60 and say, if you use a veto in atrocity crimes, you're in breach of a multilateral treaty, and that empowers us to suspend it between us and you, and start threatening that. All right.
I think that's a great question, Leila. Thank you. As I've watched Ambassador Veneviser over 20 years skillfully handle the crime of aggression negotiations, it makes me realize how slowly things move at the UN. And I think the most likely to succeed are more incremental changes, kind of working within the realm of the possible, not amending the charter, and steps like his recent idea of mandatory General Assembly discussion. Even my idea, I don't know if we'll ever get to the ICJ, but I think of it as incrementally creating more support that things need to be done. And I think we're all working in the same direction. But it is good to have the realism lens, but to push vigorously. And I think all of the above might be the answer.
Well, I'd like to.
One second.
Okay.
Because I agree that we're headed in a workaround kind of space, and one of the potential costs of working around and having it be so hard to work around is that embedded in all this is the basic prohibition of the use of force, which I consider a good thing. And as as the picture is, the charter has failed. With the charter, as the charter goes down, so does the prohibition on the use of force. And so I consider that a bad thing. I consider it something that that we have to watch out for, because the pressure is there. As the Security Council fails to step up to the plate, there will be workarounds, and the fact that it might adversely affect the use of force prohibition down the road is inevitable.
Well, a big round of applause for our outstanding panel. Thank you.